Hello everyone, this is Sachin Sawant, your UK immigration lawyer. Today I am going to talk about this question that I am being asked many times on comments on the YouTube channel and many times on the lives as well. What do I do after I have been made redundant, or how long do I have? It's mainly the time period. Now also I got a question on by one of the members asking how long do I have to do something about it. So to get another status in the UK, another application to be filed, change employer or do something about it and get some other visa status in the UK. So that is the question I'm going to address today. So by default, everyone is aware mostly uh, as per the immigration rules, the employer. So this is how the steps happen. Firstly, let's say if today your employer decides to make you redundant and today is your last date of work or whenever is your last day of work. So for ease purposes, I'm just taking today 26th of February 2024 as the last date of work. The employer has 10 working days from today, 10 days basically, it's 10 business days from today, during which they have to report to the home office through the sponsor management system. So sponsor management system is every sponsor has level 1 user access, either your HR person, some HR person, or if it's a small business, maybe the employer, the owner may have the license login. So it's called a sponsor management system. They have 10 working days from today, 10 days basically, not even 10 working days. If I have to say, it says 10 days. So if let's say today is 26th of February, so if I take 26th of February as the last date of work, latest by 7th of March, the employer should report. Latest by 7th, the employer is required to report through the sponsor management system. They go in, they select an option called as sponsor no longer wishes to continue sponsoring the migrant. Under that, there is a drop down, and then they have to report the last date of work. So they would report the last date of work today, 26th of February. So that's how the reporting is done. So the best case scenario, they can report it on the 7th. Worst case scenario, they can report it today. So, and then it goes, this reporting goes and sits in the queue of home office. Whenever the caseworker picks it up, that's when they decide. From experience, what I have seen is these cancellations, usually for students, even last year or even or last month or so, I saw several of them. Uh, for student, it comes in about 1 to 3 months. Skilled workers, it does take some time. For your calculation, always take it from the worst case situation. Let's say they report it on the 7th, and the case workers usually pick it up, let's say in a 15 days, 1 month. Let's say you take, they pick it up in a month and then they issue the cancellation. So from the date, so in my example, if I have to take it on a conservative approach, let's say looking at the current case working queue, etc., it may also happen quickly because nowadays the emails are also being sent. It's in the past there used to be a letter of curtailment that was sent. The term is also changed from curtailment to cancellation of your permission to stay or permission to enter whatever you have in the UK, that will be cancelled. The employer reported on 7th of March. Home office case were picked up on 7th of April. On that day, they will issue the cancellation email, which will state, which will count 60 days from that date. So let's say 60 days, just for the example purposes, 7th of April onwards, May and June. Let's say they give you up to 7th of June. The email will specifically state as well the last date when your visa is deemed, your permission is deemed to be ending. So what that means is, for example, you have a permission till 31st of December this year, 2024. The letter will clearly say that. What that means is, of that, the meaning of the letter is, instead of 31st of December 2024, your permission is deemed to be ending on this particular date. In my example, if they are issuing the cancellation email on 7th of April, March and April, May and June. So 7th of June is when your, I'm just taking rough figures here, but the system counts exactly 60 days. You can put it in a Google sheet or an Excel spreadsheet, put the date as 7th April plus 60 days and you'll get the answer exactly. So that's how I think their systems also work. So in my example, I'm taking 7th of June is when your visa is ending. So as per them, they've cancelled the end date from 31st of December. That is what you that is what is deemed to be happening. It doesn't happen in the physical world. Nothing is cancelled or deleted or crossed out, but that's what you need to understand. That cancellation email means your end date has been preponed, and your visa, instead of ending on 31st of December, is now going to end on 7th of June in this example. So that is how, and before latest by 7th of June. So any application you make, one of the examples I just got, someone on the questions today asking whether she has been made, the individual has been made redundant, and she's already applied for, I think, NMC registration. Maybe she's registering as a nurse or something, and so she will have to complete the process, or at least what for home office, what is important is an application has to be filed latest by 7th of June. So latest by 7th of June, if she files an application, the next application, let's say if she gets that NMCB number and a sponsorship from someone, then using that cost reference, she will have to file a new skilled worker application. Another example would be, for example, you already have a partner, you have been living together, let's say, this is a common one. I have done many such cases where an individual is already living with someone else who has some status. Let's say the person is a migrant, they are on some type of a visa, say another skilled worker visa or intra-company transfer, whatever the visa status is, global talent or any other migrant visa that the person has. Then this person can also switch and become a migrant, a dependent of that person. If, for example, there may be many options under the relationship human rights front. Let's say they have been living together for the last 2 years, they have cohabitation evidence, some break is accepted, some level of discretion is there, and an unmarried partner dependent visa can be applied. For example, they decide to get married within those 60 days period also, even if the cancellation is issued, they can get married and an application has to be filed. The important thing is the next application has to be filed, which means if immigration health surcharge and the visa application, if IHS applies, that should be paid, and the visa application fees should be paid latest by 7th of June. So in my example, I have taken 7th of June as the 60 days end period, 67 June 2024, latest by that date, that application, say that's a PBS dependent application, if it's if the main sponsor, if your partner is a migrant, say someone who is in a relationship with someone who is settled in the UK, for example, a British citizen, if you are in a relationship with a British citizen, or someone who has a pre-settled status or settled status under the EU settlement scheme, or someone who has indefinite leave to remain. So these are all are considered as settled for the purposes of any family route applications. So on that case also, if you are living together for 2 years, then you can use the cohabitation evidence and file that application on the basis of human rights unmarried partner visa. If there are any plans of getting married, then you can still get married. It applies the same way. It doesn't matter whether the sponsor, whether the person who is the main, who you are going to attach to and become a dependent, whether the main person, the sponsor, is someone who is with a limited leave to remain, for example, a skilled worker visa, an ICT visa, or any other visa for that matter, or the sponsor is a settled person, British citizen, indefinite leave to remain holder, pre-settled status holder, someone who has refugee protection, all of those. There are different applications for these. So one is under Appendix FM, family members, the other one is a points-based system dependent. But whatever you want to do, you want to switch and become someone's family member, that is possible. That application also has to be filed latest by 7th of June in my example. And if you are changing jobs, let's say you have been fired or made redundant from one job, you have already got a sponsor and that sponsor has given you a course, or even in cases where we have done critical cases where another sponsor has filed for a sponsor license, that is like taking it to the extremes, I would say. So if the new employer who is willing to sponsor you has already filed application, we have filed in the past skilled worker applications, asked the caseworker to keep it on hold, given them evidence of the employer sponsor license application, and once the license is approved, then assign the costs and then continued with the processing of the application, the skilled worker application. All those possibilities are also there. If you find a sponsor, then there is something that can be done. The sponsor can be your unmarried partner, your husband, wife, civil partner. The sponsor can be an employer who is willing to give you a job. Also, with student areas, it's a bit precarious because there are timelines to apply from the start date, of course. But anyways, if you are very close to, let's say, Jan and September are the usual intakes, and there are some limitations. I think you can only apply within 3 months or something like that. It is in the student rules. So if you fall within that, where you can file for a student visa, and if you think, let's say, you don't have much options and the option you are considering is maybe studying further, you have been made redundant from your skilled worker visa, now you want to study further, whatever, masters, PhD, whatever you want to study, and you have secured admission, got a CAS letter, confirmation of acceptance for studies from a university, you can also file an application latest by 7th of June. So 7th of June is my example where the 60 days are ending, 7 June 2024. It can be also beyond that. I'm just taking this as an example. So yes, you can also apply for a student visa to switch on to that one if uh, the university is willing to give you a CAS and you satisfy all their requirements, and that is also a workable option. So remember that anytime you lose your job or you lose the skilled worker visa, your employer is deciding to report to you or something, what is important is the only way you can stay in the UK is you need some other sponsor. It can be a family sponsor, which is husband-wife relationship, unmarried partner, etc. Whether that what they should have some status, or it can be another employer who has a sponsor license or is applying or willing to sponsor you, or who already has a CAS, gives you a CAS, you cost and you apply for your skilled worker visa. You also have the options of applying for a global talent visa. The endorsements and all are the critical aspects. Endorsement application is not for the global talent. Usually it is in two stages. One is the endorsement application and the other is the visa application. So to buy time, yes, we have filed in the past where you apply for both of them together, and once your endorsement application comes through, then your visa application will also be considered. So there are also options if you do qualify under any of those options: exceptional promise, exceptional talent, any awards, anything like that. It's quite a big area. That is one option. Secondly, if you are considering starting a business, that's not an easy one. Innovator visa, I know on TikTok and all these social channels, individuals are selling all these things, like business visa, innovator visa. It's the visa, it's quite a difficult one. I know they have like the minimum requirements that you will see on the financial side, but the important thing is on the innovator side it is possible. It's not that if you have that innovative idea, your business is scalable with the innovator and all those visas. I have a detailed video on the channel. You can search on innovator visa, you will find that. So yes, that is also one of the options if you are considering. That's a bit of a tricky one. Not everyone will be eligible. I know everyone thinks I want to start a business, I want to start a small shop and I will get innovator visa. It doesn't work like that. Innovator visa, just to give a brief hint on that, the detailed video talks about everything on the rules and all. Um, I'll just give a brief idea. It is more talking of a scalable business. For example, they are looking at the next Uber, Deliveroo, or all these big players, app-based, digitally, which can be digitally scalable. So they are looking at those businesses, not a small shop, not that you want to buy a Subway shop or something and you want to continue or open a coffee shop or anything like that. They are looking at a scalable business. Scalable is where most of those things fail. I've always seen, anytime I discuss, we consider maybe skilled worker or other options after that. But then yes, business innovator visa is also another one, global talent, skilled worker, etc., student visa. So these are some of the options that you have, and the time period is that before the end of that 60-day cancellation period. One important caveat here: in my example, I have only taken a very conservative approach. Remember that. Employer reported on 7th of March, Home Office picked it up within a month, 7th of April. They don't pick up that quickly. I know I have had clients whose applications, whose cancellations were not done by Home Office even for 3 months, some 6 months, and some even up to a year. I have dealt with many such cases where individuals were waiting for the cancellation. They already had that skilled worker visa, let's say for 3 years. After a year and a half, they were made redundant. They had the permission valid as per the grant, the initial grant. They had 3 years. Obviously, they had 1.5 years remaining on their permission. The BRP card doesn't matter. Ignore the BRP card. That's going to be completely dissolved. So after 31st of December 2024, there will be no BRP cards, just to touch on that small point. That's why everyone is getting a BRP card that expires on 31st of December. That's the important point, a small point on BRPs. So ignore the BRP card completely. Look at the grant letter which says you have been granted permission as a skilled worker from this date till this date. So there is an end date for. So look at that date. That is what matters. If you don't have that, the other way would be use your BRP card and try to generate a share code. So if you Google search for I generate a share code to give to my employer to prove my right to work, there is a link that comes up. You have to put in your BRP card, your date of birth, and then after that it confirms your status over there. That also gives you the end date of your permission. So these are the two ways how you can come to know, see your own permission yourself. The first part is where you have that PDF document when your initial visa was approved, or the email if you applied inside the UK. The email tells you the end date, your skilled worker visa is approved till this date or something like that. And the other option is if you don't have those emails or the PDF of HO approval, then you can go into the digital system, search for generate a share code for my employer to confirm my right to work, or generate a share code for my landlord. And once you put your BRP card and your details on it, date of birth, etc., it will show you your status. So those are the ways you come to know the end date of your permission to remain in the UK on the skilled worker visa. So till the time the home office doesn't send you the cancellation email. So in my case, now I will take the best case scenario. Let's say I'm taking an example here. Your visa is, your permission is valid. You have still 1.5 years from today remaining permission on the digital system or on your approval letter. Your employer has made you redundant on 26th of February. They report on 7th of March, and from then home office picks up next year 7th of January. Okay, let's say they pick it up on 7th of January. It is possible, it's not that. I've seen 50% of those who are being reported, home office does pick them up after 5-6 months or so. 50% of them may be picked up earlier, but yeah, 50% of them always goes beyond 6 months. I've seen 1 year and all also. So let's say they pick it up on 7th of January or any date next year, say 7th of January or 7th of March next year, after a year or so. So they would cancel your visa from that date forward. They cannot backdate anything. When they pick it up, when they do it. So the way the whole immigration system of UK works is, when you were outside the UK, you were given a permission. Let's say you come on a skilled worker visa and it says your permission will end on 31st December 2025, for example, not this year but next year ending, and your employer terminates you now. So let's say today they report on 7th of March, home office picks up on 7th of March next year, 7th March 2023. Your permission is still valid in the digital systems and everywhere else as per you. You have not been informed. So anytime when you were outside UK, when you made the application, you were given the letter or the email comes to you inside UK saying you have permission till 31st December 2025. If that has to change for any reason, home office has an obligation to tell you that actively, and that is not an understanding or assumption that, oh, today is my last date of work, I have to count 60 days. It doesn't work like that. So the law says home office caseworker or home office, however, electronically, digitally, they have to notify you saying your permission which we gave you. They won't go in that much detail, but this is what it means. On the cancellation email which we had given you till 31st December 2025 is now going to end on, let's say they give you the notice on next year 1st of January. If they issue, they will give you 60 days from that date forward. So January and February, for example, say 2nd of March, January and February, yeah, so I'm just taking approximate calculations. Let's say 60 days end on 2nd of March. So 2nd of March will be the last date of your skilled worker permission. You can file any application before that. All the applications that I discussed before, whether it's on the basis of a family member, unmarried partner, spouse, husband, wife, civil partner, yes, if you have a genuine and subsisting relationship, you have some evidence or all the evidence, you can file that application. You get another employer, you can file that application even till that date. So till, in this example where I'm taking a very open and wide approach, in the previous one I just said immediately if they pick it up within a month. In this one I'm saying they pick it up almost after a year or so. So you still have time. The same rules apply to you. Till that time you can live in the UK, you can stay in the UK and also switch to any other visa. Third consideration, very important, I'm coming to that one. So People always ask me, can I travel? Traveling is a big issue in this case. So once you have ended your employment with your employer who had sponsored your skilled worker visa, in my example, I'll continue with the same example. Your permission was granted till 31st December 2025. Your employer ended, your last date of work was today. Employer reported on 7th of March. The important thing is, if you decide to travel any date from the last date, anytime, the risk that you are taking is, if home office picks it up within a month and if your permission is curtailed, it is, you don't have any 60-day period. Important, this is very, very important. People always ask me, do I have 60 days? I can come back to the UK. You cannot come back to the UK. The way the rules apply is, if you are inside the UK, you get the 60 days to switch to do something about your visa status. But if you are outside the UK, there is no 60 days. So, for example, a curtailment cancellation email is issued on 7th of April in the first example, then, and you are outside the UK on that day, that's the end of your skilled worker visa. That was the last date. There is no 60 days. You will not be allowed inside the UK. If you come to the border, they will see it on the system. They won't allow you to enter the UK. Important, very important. Now, even let's say if I take the second approach where I am thinking I'm giving you a wider space where they have not cancelled your leave, this is where it becomes a bit of a tricky one. So let's say your employer has reported you travel outside the UK and you come back anytime. You are trying to come back in June, 1st of June this year, 2024. Home Office has not got to cancellation. Reporting has been done by your employer. That's a part of their compliances. They have to do it. But no one has picked it up and cancelled your leave actively. Nothing has happened. No email is sent. Your leave is technically active. There are two possibilities that can happen. If the immigration officer does not search much, they just see your leave is active, they move on, that's it. You may be allowed entry. But that is the risk that you're taking. So that is, there is a 20, I think, I don't know, it's a 50-50 chance, but I would not bet on that. So that is the other risk that you're taking. If they do find out anything, let's say sometimes they randomly check all the skilled workers, where you're working, they may ask you some questions. Oh, how is work going on, or where are you working, or etc, etc. They may do a small conversation or something, or if they want, they can investigate, they can call your employer and ask, and etc. If for any reason they have established that, oh, you are no longer sponsored, they can cancel your leave at that time and ask you to leave the UK. That they have that option. That is on the immigration officer. Yeah, so they are not going to be very nice about this, because they know that you are aware that your job has ended, so that visa is no longer valid. You cannot use it for traveling inside the UK. So that's it. So that is the other risk that you are taking. Even if it is not cancelled by Home Office and you try to enter the UK on that visa which has been reported as the sponsor is no longer sponsoring you, that visa is deemed to be not valid. Yeah, so very, very important. Only traveling is an issue. That's why I would always advise against traveling during the period, during that the period when you are not working with your employer. So if today is your last date of employment, and if you want to sort out any of your status, you want to switch to another category, I would strongly advise stay in the UK till that time, till the time you are sorting it out, or the cancellation email last date, the 60 days and all of that. So till that date, unless you file some other application, move on to another category, you should avoid traveling. So these are the two possibilities. One, if it is already being reported and cancelled and you are outside the UK, your visa is cancelled from that date. The permission is cancelled from that date only when the notice is issued. That's it. And no options, nothing doing, no entering the UK. There is no 60 days to come back and all. And if you, even if it is not cancelled, and if the immigration officer establishes by his own research, his or her own research, that, or if for example they say, are you working for your employer, and any lying over there is not going to work out and all, yeah, they are very well trained on all these things. So I would definitely advise against traveling if you are trying to move on to another category. It is legally allowed. There is nothing wrong over here within the 60-day period. Within the period, so let's say if your visa, if your permission is not cancelled for next 6 months or next 1 year, you are allowed to remain in the UK. There is nothing wrong. You are not overstaying your visa. It doesn't affect your ILR or anything like that. So you are doing nothing wrong. But if you leave the UK and then try to re-enter, then technically something is wrong somewhere. So then you are doing something wrong, definitely. That's what my advice would be. And counting this period towards ILR, very interesting. These are other questions that I've got on this area. Where can I count the period? Let's say for 6 months I was out of work, and after that I switched sponsor and I got another skilled worker visa. So just take another example. This period can be counted towards your ILR. So if you are inside the UK, you have not broken any laws, you are living in the UK, you switched within time before the 60 days expired or before you even getting the notice of cancellation of your permission, then it is perfectly fine. You are allowed to switch visas. This period will be considered as a valid period on skilled worker visa. It doesn't change anything, because on the indefinite leave to remain application, this period of 6 months is nowhere reported. There is nowhere. In the past, I know there were rules where if you don't work for your sponsor for more than 60 days, then there was a problem. Under the tier 2 general, when the indefinite leave, there was a clause, I remember that if you have not worked, then that would break your continuity of your tier 2 general qualification for skilled worker, so your qualifying period. But under the new rules, there is no such, that has been taken out. So if you live in the UK and you switch and you complete 5 years on the skilled worker permission, so the permission is important, the working with the employer is not that important for the purposes of ILR. So, and then when you file ILR, you give your latest employer's pay slips, bank statement showing the payments, letter from the employer showing that you are still required for the foreseeable future and all of that. So yes, for the ILR, those are the considerations. And important thing, now the skilled worker salaries will increase to 38,700 minimum from 4th of April onwards. And that you need to remember, I'm just throwing out all possibilities, all angles, what you need to consider. If you are being made redundant now, and if any time from this point forward, and if your new employment application, the skilled worker application, is filed on or after 4th of April, when the salary increases to 38,700, you have to meet the new requirements. Whatever your salary is, for example, currently you are meeting the minimum salary requirement of 26,200, which is the minimum as per today. But if you are being made redundant on the current salary rate for your job code and the minimum salary for the skilled worker application, let's say today it is 26,200, if you filed and your current visa is on that basis, when you file your skilled worker visa application for the new employer, if that application is filed on or after 4th of April 2024, when the skilled worker minimum salaries increase to sponsor someone on a skilled worker visa, the minimum salaries will go up to 38,700. So once that change has happened, if you are filing the application after that, those minimum salaries will have to be paid. So at least 38,700. I'm considering everything normal. I'm not taking new entrant, PhD or any other occupation, shortage occupation, care worker occupations, or that new list that is going to come. I'm taking a normal skilled worker application. If you are currently under the 26,200 minimum salary requirement and your job is being made, your job has ended, and if you are filing a new skilled worker application, that is another consideration you need to remember about, is 38,700 minimum will apply, because you are switching employers after the change has been implemented on or after 4th of April 2024. This is all I wanted to talk about in this video. If this video has added value to your life, to your knowledge, do subscribe to our channel, like this video, share it, comments, write down whatever is your experience. If you have been made redundant, how long, this is very, very important. Sharing information is important. So please, we always want the latest information that goes to individuals who are in who are in these difficulties, who have lost jobs, etc., etc. So how long Home Office has taken to send your cancellation email, please write in the comments. If you are in such situation in the last 1 year, how long did Home Office take to cancel? Or even if you have not received and let's say your job has already ended, just mention briefly. You don't have to give all the facts of your case. In general, the time periods or any dates that you can say, you don't have to write your names and all. Yes, it is a critical matter, it is a matter of data protection, I understand that, but yeah, it will help others. It will also help me to explain in other videos as to different individuals what experiences they are going through, and this will help someone else in a similar situation. So this is what all I wanted to talk about today. Do Subscribe to our channel, and thank you very much.